So are you buying or selling a business? Here's how you can avoid expensive lawsuits. And I'm going to really direct this toward the buyer, but same thing goes to the seller, because if the buyer ends up having problems, guess who they're coming after? So it applies to sellers as well. All right, so if you're the buyer, let's say you're taking over a business that the original founders are retiring, and so you're taking over their store, for example. And so make sure that whatever documents you're signing before you pay any money, it includes at least a rudimentary list of what you're buying. And how the transfer is gonna work. So maybe you're buying existing inventory that's located in a certain warehouse. Maybe you're buying the existing orders, all of the equipment, recipes, processes and procedures, maybe marketing collateral, signage, maybe a lease that you're taking over, or a building. In addition to all that tangible, sort of obvious stuff, one of the most important things that is so often left out or inadequately dealt with is the trademark. And so what is that? And it's not about the magic word trademark. It's about recognizing that what that is the branding. It's the name. So what you want to look for, and this is part of your due diligence before you spend any money, is you want something in writing, ideally showing that they have a trademark, a USPTO trademark registration in force, showing that it's still active, that it has been renewed. One that is expired is worthless. That doesn't mean anything. If it's expired, it is like it never happened, okay? So it needs to be one that's in force. And if they don't have a USPTO, maybe they have a state trademark registration, but you want to ask for that, because if they have those things, especially if they have a federal one that is in force, that is valuable. And that can give you some additional, serious peace of mind, knowing that you are protected and able to defend the brand and the reputation of the goodwill that you're buying. That's why that matters, because it'll save you tens of thousands of dollars of legal fees if you are starting out with a U.S. registered trademark that is in force. So if they don't have that, and very often they won't, then there's a couple other things you want to have in writing. And one is that you and only you own the trademark or trademarks. And I would encourage you to list what you believe the trademarks are. So that's going to be, if it's a store, definitely the name of the store, maybe some product lines, maybe some slogans. All right, so whatever it is, if you think that it's something that customers associate with the store so that they recognize the store, if they see that on a tag or on an ad or something, then list that as a trademark and make sure that they sign off on it so that you're getting what you believe you're paying for, okay? You want them to say in writing that you and only you own that, and at the point at which they're making the sale, that they are unaware of anyone else who has any rights to those names, those trademarks. That's going to be a really important question, because you also want to find out if they're in the middle of a lawsuit, or if there's someone out there who every 6 months sends them a cease and desist letter. Maybe that person hasn't gotten around to suing, but after you take over, they will. So you definitely want to know if the trademarks that you're buying are subject to a lawsuit before you spend money and allow the people that created that situation to exit. Okay, so definitely ask them, and this is something we would call like a representation and warranty, where they have to say, I'm unaware of anyone else that has the right to this name. That can also uncover all kinds of interesting things. And at worst, if they lie and they say they're unaware, they sign the document saying they're not aware of anyone else, and then you find out that they did have some encounters with someone else, then you have a much easier lawsuit against them for violating that representation, that warranty. All right, so again, I also mentioned you want to know whether there are any trademark registrations. That's important. You also want to take a look at those registrations, make sure they're in force, as I said, and also make sure that they are they're on the current branding and not something old. You won't be able to renew them if they're, if the design of the logo has changed or something. and all they have is the old logo, then that's something that's important to know, because that's something you're going to have to spend money to register the new logo. All right. Again, the history of the trademarks, any enforcement issues, also any coexistence agreements. Have they agreed to stay in their lane? With some similarly named business somewhere, you need to know about that, because you're going to be held to abide by that agreement, whether you know about it or not. So make sure you ask, are there any coexistence or other agreements with other parties in the United States or elsewhere about these trademarks, including, like, are there geographic limitations? Are there any license arrangements? Have they licensed the trademark to anybody? You want to know about that, of course. I would also ask them, if it's not registered, I would ask them why it isn't registered, and just get them, maybe they say we didn't think of it. Maybe they say someone told us it couldn't be registered. That would be useful to know. Maybe someone, maybe they were prohibited from registering it because there was someone else who was using it at the time, but now that's cleared and you can register it. It's a good question to ask. If it's not registered, why not? And then the last thing I want to mention is that a trademark registration is not the same as trademark rights or the trademark itself. This is a really tricky situation. It's a tricky nuance there, and I'm going to do a whole other video about it next week. But just because someone has a piece of paper virtually that says that they own the trademark registration at the USPTO does not mean that they actually have any rights to that trademark, because trademarks, unlike copyrights and patents, they don't exist outside of a business. So you can't buy a trademark and just hold on to it and not use it. You can't buy a trademark that is associated with someone else's business and then try and sell it back to them. If you're not doing that business, your trademark is an illusion. You don't actually have it. So don't be fooled that if they say, yeah, we have the trademark, here's our registration certificate. If they're not currently doing that business, if they're not currently selling that kind of product, then they don't actually have those rights, even though there's a piece of paper with the government, signature on it that says that they do. It looks like they do, but they don't. So this is where you definitely want to do some due diligence, look into it, investigate what rights they actually have before you give them a bunch of money for things that are illusions. Okay, so hopefully that was helpful. Again, Catherine Cavella, IP Works Law. Thanks. Bye-bye.